Next point is, according to Indian Hindu Succession Act of 1956, what will happen to people who have died intestate? That is, they have not made a will at all, but they just die suddenly. The reasons could be many things. Health reasons, could be an accident, could be any other unnatural death. So what will happen to those cases where they have a wife and children surviving the dead person?
According to Hindu Succession Act, if a person dies without executing, without writing any will, and automatically there is who will be the legal heirs? There are some guidelines in the Hindu Succession Act. According to the Hindu Succession Act, wife will be naturally the first legal heir, wife. After that, children.
They call the class 1 heirs.
If the deceased person has got a mother, she will also be considered as one of the legal heirs.
Yes, but not the father.
The father will not be
considered.
So, if you do not, if you have not written a will, automatically it will be divided among your legal heirs, your wife, your mother, if she lives. After that, your children, both female and male, will have the same share, same
equal share.
So this is what the Hindu Succession Act says. Suppose if you are unmarried, and you suppose if you have no children and the wife is no more, then the class 2 legal heir will be coming only at that stage, because there are two classifications in the Hindu Succession Act. Class 1 legal heir, secondly class 2 legal heir. Class 1 legal heir is naturally your wife, mother and children. If you do not have all these persons living, and it automatically goes to your second class legal heir. Who are all the second class legal heir? Your brother, your sisters. They will be the father. Father will be going as class 2.
Or demised daughter's daughter, demised son's daughter.
If son is not, son is also not living, automatically the grandchildren, it will go. So, class 2 legal heirs, so many problems will be coming. And for class 2 legal heirs, mostly Tahsildar will not be giving the legal heir certificate. And now Madras High Court and Madurai High Court has given several directions to the Tahsildar, stating that you have to give the class 2 legal heir certificate also. But previously, they refused to give, some of the Tahsildar will be refusing to give class 2 legal heir certificate. In that case, what you have to do now, you have to file a declaration suit before the civil court and seeking direction from the civil court to give the declaration that they are the class 2 legal heirs.
Yes.
In that case, you have to produce all the records and everything.
Yes.
To justify that you are the brother and you are the sister. After that, the court will pass a declaration degree stating that you are all the following persons are the class 2 legal heirs. That was the practice followed previously. But nowadays, the court has given direction to Tahsildar to give certificate, to give the legal heir certificate even to the class 2 legal heirs. This is how you have to partition the property.
Apart from class 1 and class 2, there are also agnates and cognates. Agnates come from blood relation, from the male side, and cognates invariably from the female side. This is what the law says. What's your take on this? Are there many cases representing agnates and cognates?
Suppose the person had died, wife had also died. They didn't have any children. How the property has to be distributed? In that case, what the law says is that if it is the self-owned property of the father, automatically his relatives, his brothers and sisters should get these shares. If it is the self-owned property or the ancestral property of the wife, automatically it should go the wife's class 2 legal heir.
Yes.
So that has to be determined. Suppose if they don't have any children, who is the class 2 legal heirs? Father's relatives or
the mother's relatives.
Law says that if it is the earning made by the father, and if it is the ancestral property of the father, father's class 2 legal heirs should get it. If it is the yearning made by the wife, or it has come from the ancestor of the wife, automatically it has to go to the wife's
side.
This is how the property will be distributed.
Even the sections are very clear. Sections in Indo Succession Act from 8 to 13 onwards, section 8 to 13, they talk about the apportioning of wealth from the male, from the deceased male side. And for ladies, they do have section which is between 15 and 17. They categorically say how the property was acquired, whether it is self-acquired property, like you said, or whether it is come from the ancestral property. So the classification is very clear. And whereas, but in for ladies, what they've said is they've categorized into 3, which is her self-earned, or from her husband, or from her parents' side. So as you rightly said, so the category or the division goes as per class 1, class 2 heirs. My next question to you is, when you have the will, now the current trend is making out settlement deed, which is the stamp paper cost is 25,000 plus the other charges when you go to the registered office. The settlement deed also says who the property is being settled to at a future date with the living rights to the person who is making the settlement date, whether it is for the husband or the wife, as you rightly said, and the living rights totally going to the other partner, the surviving partner, and with no alienation rights. They've got the full living rights. Now the current trade is settlement deed, and how do you feel? Are there any examples that you can give for settlement deed?
My advice to the parents about the settlement deed is, you don't execute the settlement deed in favor of your children when you are alive, because you should have personal security till your lifetime.
Correct.
I have seen so many persons who had settled the property in favor of the children. After the children had taken away the property and ignored the parents. Nowadays the trend has gone in a different way. Youngsters are now going abroad, leaving the parents
behind,
and they do not look after the parents. And if at all the property is with you, you can use it, you can even sell it, or you can stay in the same house. Recently, one daughter and the father had settled the property in favor of the daughter.
Okay.
After the daughter wanted to sell the property, and he refused to vacate father, and he had thrown away her father from the house. So neighbors have come and rescued the person. And if at all, if you settle the property during your lifetime, there is no security for you. That is what I am telling is, don't go for settlement deed. What I am telling to the parents is, don't give your property to your children when you are alive. Normally, I have made it as a practice. People will be coming to me for writing a settlement deed. If I register a settlement deed by drafting, and by doing drafting and everything, I will be getting 22 to 20,000 as advocate fee. Normally, I will not take such assignment. When anybody comes and asks me, sir, you write a settlement deed, I will be advising them, and I will not be taking it, because they are innocents. They do not know the rule of law. We have to advise. You should tell that this is the danger which you have got if you write the settlement deed when you are alive. So I used to advise them, no, I will not execute it, I will not write it, but my advice is, don't register a settlement deed. Recently there was one incident, some 5 years back. One of my close friend had come, and he said that I wanted to settle the property in favor of my wife, his wife. I said, why you are in a hurry? You are very much alive, wife is very much alive, why you are settling? He says that my wife is insisting daily that I have to settle the property in favor of her, because she says that she cannot believe me. I said, don't do that blunder. Even if she is your wife, you look after your wife, because he is a very sincere person. Even after retirement, he is working in a private company. and he has been he has been looking after the family. But wife wants husband to settle. I advised him, no, don't do that, and you will be in trouble. And he was insisting me, but I said, no, I will not do that. If at all you want to go to some other advocate. After that, he dropped the plan. Now he is telling me that you have saved my life. Now only I am seeing that because my wife wanted to sell the property, she is insisting me to sell the property. If I have settled the property in favor of her, she would have sold the property. So both husband and wife are partners, but they both should believe that they are individually they are different. They should think of their own security. Even if the husband is there, you should think of your own security. Likewise, husband should think of his own security, because the world as the joint family has disintegrated nowadays. So you should be very careful about your welfare, and that is what I said. And in another case, one old man, he was 85 years old, and he came to me, and he had got a house, and he is getting 1.5 lakhs rental income, and he has got 3 daughters, and the son-in-law, all the son-in-law, they have joined together, and they have been insisting their wives to ask for settlement from the father, even when he is alive. And he was coming to me, he said, sir, I want to settle my property. And I said, I will not do that. It is a sin if I do this, because you people do not know about the society nowadays. I have been seeing so many people. The world is going in a different way. You are getting 1.5 lakhs of income per month. You do one thing. You give 40,000 rent to all your 3 daughters. You keep the 30,000 for your own
expenses.
Safety. But don't settle, because if you settle the property, they will be getting all the 1.5 lakhs rental income for them, and you have to beg from them. You don't do that. But he said, no, I have to settle. Then I told him, you go to some other advocate. He went to some other advocate, he had settled it. After that, he was in a very great trouble, he had suffered a lot. And he was telling me, what you have told is correct, because this is the thing which had happened. I said, this is how the society has been changing. And there was yet another incident, because viewers should know what is happening in the society. A DSP, and he was my batchmate, DSP, and he had lost his wife. He has got 2 daughters, and he had retired. He has got 45 lakhs of rupees as pension settlement, 40 lakhs. One daughter, she got married. Another daughter, she remains unmarried. He has been looking after alliance for the second daughter. And what happened after he retired? The first daughter's mother-in-law, she was telling his daughter, your father had got 40 lakhs of rupees as pension settlement. You go and get 20 lakhs from him, being your child. First daughter, she had come to him, and she was asking, my mother-in-law is asking 20 lakhs from you. He said, your sister is still remaining unmarried. I have to get alliance. Yes, married. You keep 20 lakhs. You keep 20 lakhs. So first daughter said that, okay, you keep 20 lakhs for my sister. You give 20 lakhs. Otherwise, my mother-in-law will be creating problems. Then he had given 20 lakhs. And after that, what had happened? He was drawing 50,000 rupees as monthly pension. And again, after some time, that mother-in-law was asking his daughter to go and get at least 20,000 rupees per month from him. And he was telling me, he was crying. I went for a marriage. He came to my lodge and he was crying. He said that my first daughter has got 20 lakhs of pension of my pension settlement. Monthly pension she is asking 20,000. I'm getting only 50,000. And I said, how can I survive? And mother-in-law is saying that your father is alone. 10,000 rupees per month is enough to get 20,000. He was weeping. And I was telling him, I will draft a complaint. You just sign in it. We will see that she has been sent to jail. And he said, no, my daughter's life will be in trouble.
It will be at stake.
So then I came back. After 2 or 3 days, that person had died. This got such a meant be everything to your children. And after your lifetime, you can write a will stating that after my lifetime, all the property can go to my wife first. After her lifetime, it may go to my children. This is how you have to follow the procedures. First settlement deed, no settlement deed. There is also a conditional settlement.
Yes.
Everybody will be writing that this settlement deed will be coming into effect after my lifetime.
Yes.
But even if you write this, revenue records and everything, they are changing the name. If your children goes and gives the settlement deed, they do not bother about whether it is coming after the lifetime, because they will be transferring the revenue records and everything. So they will be taking the rent and everything. So even if it is a conditional settlement, don't do that. And you should also know one important fact, that if you write a settlement deed, it cannot be cancelled. It cannot be cancelled. So there should be some clear indication that the settlement deed can be cancelled. But if mostly people will not write like this, so don't go for settlement deed. Go for a will. That is what I want to advise.